Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. If you have been following the case styled as Idaho versus Kohberger, you are undoubtedly aware that this very high-profile criminal case was scheduled to go to trial during the summer of 2025. That trial was canceled on July 2nd, 2025, after Mr. Kohberger changed his plea to guilty to all 5 of the felonies that he was scheduled to stand trial for. Just prior to that, Judge Stephen J. Hippler denied Mr. Kohberger's request for an adjournment of the jury trial. And one of the reasons that he raised was this unprecedented pre-trial publicity, including books that had been written about the case, interviews that had been given by parties that were involved in the case, but most critically, in my opinion, the fact that in May of 2025, days before the final pretrial conference, there was an investigative report made by mainstream media regarding this case. If you watched that pretrial conference, as I did, in fact, we were doing a live just before the pretrial conference in anticipation of this very important hearing before Judge Hippler. You know that that final pretrial conference did not start on time. It was late in starting in open session. The public later learned the reason why the final pretrial conference did not start at the time that it was scheduled to start. When, for example, there was an order regarding the May 15th, 2025 hearing that was scheduled that day. Again, this is the day of the final pretrial conference, where Judge Hippler wrote, "The purpose of this order is to explain the reason the sealed hearing this morning, May 15th, 2025, held to inform the parties about the orders to maintain records that the court entered today." And then there was a second reason given here. This was signed Judge Stephen J. Hippler as district court judge. During the open session of that hearing, the court addressed his concerns about information concerning the leak of under seal, possibly evidence in the case, to mainstream media. And he was very terse. He appeared very concerned. And he had indicated that he would be submitting orders to both sides, that is, the state and the defense. And they are here for your consideration. The order that went to the state was a little bit longer than the order that went to the defense. There's some additional information at the end of this document and records hold order that went to the state that included language that was not in the defense's order. Both of them talked about in the first paragraph, based on sensitive information not previously circulated that was reported during a recent TV program related to this case and the defendant Brian Kohberger, it appears likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order. Such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impedes the ability to seat an impartial jury and will likely substantially increase the cost to be borne by the taxpayers of Latah County to prosecute this case, by extending the time it will take to seat a jury and potentially requiring a lengthy period of juror sequestration. Accordingly, the court finds it is imperative to attempt to see that the source of such leak is identified and held to account, and that doing so is the best deterrent to future violations. Accordingly, the court finds it appropriate to exercise its discretion by entering this order. And if I could interject some comments, some opinions here first. Given what the court has said here, this goes to Mr. Kohberger's due process privileges here when he's talking about these events significantly impede the ability to seat an impartial jury. That is a requirement of the 14th Amendment to the United States Constitution, which you may have seen raised throughout the more than 2.5 years that this case was being prosecuted. The defense would frequently cite to the 14th Amendment, and that constitutional guarantee at the federal level mandates that when the government is seeking to take life, liberty, property, that person is entitled to due process of law, and due process of law has been interpreted to include the right to an impartial decision maker. So with this order and this language here that the court's saying that on May 15th, coming out of this closed session hearing with the parties, that the court felt that it was someone from the prosecutorial or potentially law enforcement who was responsible for this leak, why it is that he did not provide an adjournment, grant that motion for an adjournment of the trial, requiring Mr. Kohberger to go to trial and to confront witnesses against him without knowing if these witnesses or a witness was responsible for this leak, aka violation of a court order, aka contempt of court. In my opinion, I provide these opinions only as part of my thoughts. My commentary is guaranteed by the First Amendment to the United States Constitution. Now, if you look at the state's version of the document hold order, you're going to see additional language towards the end where the state is required to do some additional things over and above what the defense was required to do. And in giving an opinion, again, I believe this is consistent with the court's belief on May 15th, 2025. It wasn't the defense, but it was the state or someone associated with law enforcement who the court felt that day, coming fresh out of that hearing behind closed doors, of which side was likely responsible for this leak. In looking at the recent order that Judge Stephen J. Hippler rendered concerning documents that would be sealed or unsealed, he has decided to keep the hearing minutes from that closed session sealed from public disclosure. In my opinion, that set of court minutes, which would take down the key events that happened at that hearing, I believe is crucial information that the public has a right to know of what was discussed that day. The reason for not releasing those court minutes to the public is that this document references discussion between the court and the parties regarding the potential leak of information in this case, which subsequently resulted in an investigation, and this information is exempt from disclosure. Today is now October 26, 2025. It is approximately 5.5 months since this behind the scenes, yet another closed and sealed hearing from the public occurred. And the public has no information regarding when did this investigation start, what were the results of the investigation, We've had both sides hinting at it in certain filings, but as far as I know, this is the first time that the court has come out and stated that not only was there an investigation, as though the investigation has concluded or is very well on the way to conclusion. These court minutes occurred before any investigation commenced. And I'm not understanding why these minutes, even in a redacted format, is being withheld from the public. This coming Thursday evening, we are scheduled to have a live event. I don't do very many lives. We're going to do one this Thursday evening, the 30th, 8 p.m. Eastern Standard Time. And it's to announce a new project that we have been working on for some time here at the Indie Zone. It is a completely DIY, do-it-yourself film, completely independent from soup to nuts, A to Z. We reject everything corporate mainstream when it comes to matters regarding the First Amendment, and our project, an independent film entitled Idaho versus Kohberger and the First Amendment, is the subject of our forthcoming live, and that is scheduled for delivery in 2026. I hope you'll be able to join us this Thursday evening and provide your comments, your input, your thoughts, your opinions, as you are entitled to do under our very precious First Amendment to the United States Constitution, which guarantees freedom of speech, freedom of the press, and freedom to petition government for grievances, amongst the other 5 freedoms that are encompassed in that very First Amendment that appears in the Bill of Rights. Until next time, this is Kathy. Thank you very much for joining us here today.